In today's video, we're going to be talking about common outcomes in petty theft and grand theft cases in Florida. My name is Adam Rossen. I'm the founder and owner of the Rossen Law Firm. We handle criminal defense and white-collar defense in South Florida. Me and my team, we believe bad things happen to good people, and we're here to help them achieve their best future. So stay tuned. So first of all, when we're talking about petty theft, that's a misdemeanor which has a max jail time of either 60 days or 1 year. If the value of the goods are under $100, then the max sentence is 60 days in jail or 6 months probation. If the value of the goods is $749 down to $100, then that's a first-degree petty theft where the max punishment is up to 1 year in jail or 1 year of probation. So if we're talking about grand theft, again, the value of the goods is going to determine what levels we're at, what degree felonies we're at with grand theft. But for it to be any type of grand theft, it must be $750 or more. So between $750 and $20,000, that's a third-degree grand theft with a max punishment of up to 5 years in prison, 5 years of probation, or any combination of those two. Now, if the grand theft is over $20,000, well, that's a first-degree felony with a max punishment of up to 30 years in prison. So there's a very big difference, between petty thefts, a third-degree grand theft, and a first-degree grand theft when we're talking about time. And on resolutions on this, common outcomes, right? So a lot of this depends on the client's prior record and the facts of the case, meaning, was this a scheme that was going on for years and years? Was this a 1 or 2 time impulsive decision? Maybe our client got caught up with some friends who were the masterminds of something, and they were just said, hey, can you make a quick buck if you help us? And the client did, right? It also is very big on not just the facts of the case, but how strong the prosecutor's case is. A lot of these cases can fall apart or crumble as we litigate them. So what may start off as a rock solid case from the prosecutor's perspective might kind of go down in the dumpster. And if it is, well, then we're talking much better resolutions, as the case progresses and we do more work. So that's really ultimately the two main factors is prior record, well, really 3, prior record, facts of the case, and strength of the case should it go to trial. Now, when we're talking about petty theft, oftentimes we can work out a complete dismissal of the charges with the state attorney's office. A lot of times it can be through a diversion program, either through the court or the prosecutor's office. And usually these diversion programs are, you do a little bit and you get a tremendous benefit. So it could be an anti-shoplifting course, community service, no return, especially to the store if it's a shoplifting petty theft. If there's any out-of-pocket expenses such as restitution, making sure that that's all paid, and the alleged victim is 100% whole. If you have certain priors and we can't work out a diversion, which, again, is a guaranteed dismissal of the charges, then we'll have to fight the case, right? And then we really, do our investigation and we'll ask for depositions. And depositions are not guaranteed for misdemeanors in the state of Florida, but we always ask. One of our firm policies is, if we can ask for a deposition, we're going to ask for it and we're going to try, because that's how you win cases, by doing more work. I could tell you a quick story, but I had a loss prevention officer on a petty theft shoplifting case who was a civilian employee from Walmart. But really, these loss prevention cops they're not cops, they're wannabe cops. And he was really frustrating me, so I spent an hour and a half grilling him, hard as can be, about this case, and really just kind of going at him and exposing all the things that he did wrong, going into his whole, background, that he had applied for, I think, 3 different police agencies to work there and been denied at all 3. And that work got the case dismissed when there was no diversion program on the table. Well, some people might say, well, Adam, why'd you do all that work for a simple little shoplifting case? And my response is, because that's what the client deserves. And that's what the client needs to help them achieve their best future. Because who's going to hire a thief, right? Who's going to hire a shoplifter, somebody who has a crime of dishonesty on their record? So those things are very important to me, and everybody at our firm we're very passionate about. And, so there's depositions, there could be motions, it could be a trial, right? Everything that we have in our repertoire, if we can't get a dismissal, we're going to explore in order to get the best result possible. And then really at the end of the day, it's either make the decision of, do we accept some kind of plea bargain, or do we go to trial and, roll the dice and see what happens at a trial. And it's kind of similar when we're talking about felony cases. Really, it's a very similar analysis. Obviously they're more serious. They're usually more complex. So the timelines and the discovery process is usually longer. There's more work that we have to do. And the max, on a third degree is 5 years in prison, probation, or any combination. And in felony cases, what we have is a felony score sheet in the state of Florida. It's the Criminal Punishment Code score sheet. And the way it works is, it's mathematical equations depending on prior record and the crime and different things like that. And if you get to 44 points, you're supposed to go to prison. Now, of course, there's exceptions to the rule, and there's exceptions to the exceptions to the rule. So just because you score 44 points does not mean you're going to go to prison on any felony in Florida. The good thing about a felony grand theft, a third degree, is it's a level 1 offense, which is the absolute lowest offense level in the state of Florida. So it gives you 4 points on the score sheet. Okay, so if you have quite a bit of priors, especially violent or dangerous priors, you may score prison on, if you have a grand theft, but 99% of the people that we encounter will be nowhere near mandatory prison or 44 points. So it's, not that big of a deal on those type of cases. However, when we're talking about complex fraud, and again, this stuff is in the state court level, not the federal level. The federal level is completely different, and we'll be talking about that in different videos. But when we're talking about felony grand theft, first degree felony grand theft, over 20,000. When we're talking we have a max punishment of up to 30 years in prison, probation, or any combination, that's a level 7 offense. So that crime by itself gives you 56 points. Obviously, that's higher than 44. So when we do the mathematical calculations, if you've never been in trouble before and you have a grand theft charge of more than 20,000, you're immediately looking at a minimum of 21 months in Florida State Prison. So these cases are tremendously huge. There's a lot at stake. And then again, that's without any enhancements or points for prior criminal history. But again, I want everybody to understand, just because you're scoring 56 points, minimum 21 months in prison, does not mean you will get a day of prison. Not necessarily, because there's many ways to depart downward and get around these the Criminal Punishment Code score sheet. So that is something that I want everybody to really understand and just be crystal clear is it does not mean your life's over or you're definitely going to prison. So then the big question is, well, how do we get around mandatory prison? Well, one way is to beat the case at trial. Another way is to file legal motions where the judge dismisses the case or at least strips so much evidence away that the prosecutors have nothing left or very little left to where they have to dismiss the case. The third way is just straight up negotiations with the prosecutor, maybe mitigation, showing their client's good character, maybe many years of good moral conduct, right? And all the good that our client has done in the community. So just, straight negotiating with the prosecutor, working on mitigating circumstances to go down below. Another issue could be if the case crumbles and falls apart. Maybe there's witness issues, there's factual issues, there's issues with pieces of evidence, again, that they may have, but there's a big difference between do they have it and is it admissible at trial? So if their case kind of crumbles, well then they know, that we're going to probably win at trial, so they're going to have an incentive to negotiate with us to give us a much better deal pre-trial. We can always go to the judge for what's called a downward departure motion. We're going to cover downward departure motions in a separate video in great detail, but long story short, judges are allowed to say, you know what, I don't think that's necessary. I'm going to give probation, or I'm going to give maybe a few months in jail, but not, 21 months in prison. And the last real big way is what's called a youthful offender motion. So if the client is under 21 at the time of the offense, then the client is eligible to file a youthful offender. Doesn't mean the judge is going to grant it, but if the judge agrees and grants the youthful offender motion, the punishment is capped at 6 years. So technically the judge could still sentence them to 6 years in prison, but in a situation like this, most likely they would grant the youthful offender and give probation and other kind of stipulations to help the young client, move on and become a better person, right, and a more productive member of society. So the youthful offender is very key. And the really good thing about what we call a YO is that it's under 21 at the time of the offense. So we're allowed to work this case for 2, 3, 4, 5 years. The client could be 25 at the time of sentencing and still be eligible for a youthful offender sentence if they were 20 years old at the time of the offense. So those are a bunch of great common outcomes on what can happen on your petty or grand theft case in the state of Florida. We hope this was educational. If you ever have any questions, give us a ring. Find us on YouTube and other areas of social media. We love helping out people. And our firm's motto is we help good people when bad things happen so they can achieve their best future.